Well, good afternoon. I'd like to welcome everybody to the webinar today. Just a couple real quick housekeeping notes. First, we got everybody muted. We do that just to cut down on some of the background noise. So as we work through the webinar, you've got the chat box or the questions box that you can put questions in. Just drop those in there, and when we get to the end of this presentation here in maybe 30-35 minutes, I will look at those questions and answer any questions we have. You'll also have all my contact information when we wrap up here in just a little bit. We also record this, so I will make this available, as a recorded webinar. If you have colleagues that couldn't make it this afternoon, they'll be able to view it whenever they want to. Same thing with the slides. If you want to save yourself taking some notes, we'll offer those online as well, where you can download the slides and all the information that we're going to cover today. So without really anything else, let's just go ahead and get started. I've been working with Dina, and we had formed a partnership, I think about a year ago, with some special pricing, of which we'll provide for you as well. And I can tell you, I was looking at the pricing, right before we started, and probably Dina did a fantastic job negotiating on your behalf, because it's some of the most competitive pricing that we offer to anybody. And we do have some partnerships with some really large national, insurance carriers, and this actually beats that pricing. So what I thought I would do is first of all, just kind of walk through a workshop that I did recently for the Indiana Chamber of Commerce on, just kind of a warning how background checks can get you in big trouble. I mean, we're really in an extremely unique climate these days in terms of, what's going on in the world. And I've got kind of 4 topics here, of areas of, interest to any employer and kind of what's going on in those areas. But I do want to mention one thing real quickly, is that, as Indiana organizations, law takes effect Monday, July 1st, that will, have an impact on your background screening process. And 2 of the things, one of the laws basically says, if a record's been expunged, that you can no longer, ask about that information. And really, you shouldn't be asking about expunged information to begin with, because, under kind of federal law, once a case is expunged, it's as if it never existed. And Indiana just kind of honed that down and said, you shouldn't be reporting or asking about expunged cases. And more than likely, most of you are not doing that. So that one's not going to have probably a tremendous impact on your organization. But the other law was actually passed a year ago, July. In this particular law, they gave it like a 12-month grace period, takes effect Monday, which restricts reporting of criminal non-convictions. So if one of your candidates has been arrested, pretrial diversion, any kind of activity where they are arrested but the case is adjudicated as not guilty or dismissed, it is not reportable under Indiana law effective on Monday. So Indiana will only allow the reporting of convictions. It's a huge, huge step that the state has taken, but it kind of is indicative of what we're going to talk about here in a minute, how the pendulum has kind of shifted in this country away from security and protection, kind of what we saw after 9/11, and it's kind of moved into another arena, which is more protection of the consumer. There's been a lot of kickback related to, ex-offenders, and how, they believe that proliferation and background screening is one of the things that's causing them difficulty and causing them to recidivate, is because they can't find a job. So a little bit on my background. The founder and CEO of Safe Hiring Solutions. We're in Danville, Indiana, so we're a west suburb basically of Indianapolis. I'm also the co-founder and CEO of eReference Check, and I'll just briefly mention eReference Check, but if you can carve out another 30 minutes this afternoon, we have a webinar. It starts at 2 o'clock on eReference Check, and what it is, it's a totally automated reference checking platform. So instead of traditional phone-based reference check that take you a lot of time, cost you a lot of money and labor, and generally elicit very little information. This is a software program. It is competency based on these competency surveys. So you may have 4 to 5 competencies with 3 to 4 questions per competency, and so once you enter their name and email address, then the system does everything for you. It sends an email to your candidate and tells them, hey, you need to log in and enter your references. They click on a link, they enter their references. Once they save that, it sends the reference, this competency-based survey to complete. They come back in, it aggregates the scores and reporting. I'm not doing a lot of justice here in 30 seconds, but certainly you're welcome to participate in the webinar after this one, or we do have a recorded webinar on our website that you can take a look at on e-reference check. Prior to starting these companies, I was a violent crime detective with the Metro Police Department in Nashville, Tennessee. I'm a native Hoosier, grew up here, graduated from Wabash College, but moved south to become a detective. Safe Hiring, we have about 2,600 clients across the United States. Our client base is very diverse. We work here in Indiana with about 230 Indiana school districts. We work with some large and small healthcare networks. We've done a little work for the NFL. We work with volunteer organizations internationally like Kiwanis. So we have a really large and diverse client base. And my background is I still do a lot of consulting work on violence prevention for like Department of Justice and Defense and Homeland Security. And that's really kind of the foundation that Safe Hiring Solutions was found on, is really kind of doing it correctly, because what we're going to see as we look at kind of some of the truths about background screening and the background screening industry is that the industry itself is highly unregulated. And what I mean by that is there are no standards of care. So if you were to ask 20 background screening firms, how do you define a background check, you're likely to receive 20 different responses, because there's no kind of standard definition in the industry of what it should look like, what it should consist of, how it should be done. And so without this standard of care, what has happened is you've had lots and lots of companies, start, because generally in most states, the majority of states, there's no requirement for starting a background screening firm. You don't have to have a PI's license or any kind of special licensure or experience. I mean, anybody can do it. So what has happened is you've had lots of companies pop up in this industry, and they tend to focus on offering really low quality, database-driven type products, which first and foremost are terribly incomplete, and then secondary to that, they wouldn't be FCRA or Fair Credit Reporting Act compliant, which we'll look at here in just a little bit. So, as I say, highly unregulated, the FCRA does provide strong consumer protection, but it doesn't have any standard of care beyond, using up-to-date information. So historically, the background screening industry has, delivered very low quality product and services. Examples are like limiting the reporting to 7 years. This has become an industry norm. It always has been. There's no reason for it other than 20 plus years ago, the Fair Credit Reporting Act did restrict convictions to 7 years, but that was amended 20 years ago. And with that amendment, it basically said you can report convictions as far back as you find them, and we'll let you report arrest data, for a 7-year period. So in Indiana, even on Monday, when it restricts the reporting of arrest information, it still would say that you can report a conviction as far back as you find it. If you find a conviction 40 years ago, it's still reportable in Indiana. So we believe there's no reason that we should be restricting your information unless we legally have to. And if we don't have to, we're not going to restrict it. We're going to give you everything we can find and let you make informed decisions based on your policies and procedures. Same thing with alias names. We see a lot of, either not searching the alias names or adding additional search fees when you search an alias name. which is the only way to do background screening correctly is you're going to have to search those names and other names. If somebody's been known by more than one name, and especially in recent history, if they've been known by more than one name, the only way to do that correctly is we've got to be able to search both of those names, and so we include that within the package price and don't charge extra for that. So this is kind of what a best practice in background screening should look like. I know I've had some experience with healthcare agencies here in Indiana that were relying on the Indiana limited criminal history. I can tell you that in Indiana, the schools, the state did away with the limited criminal history being an option for school districts back in 2009 when they passed the expanded criminal history statute. And part of that is because the limited criminal history here in Indiana has huge holes and gaps in it. We watched as a large school district here locally had hired 2 sex offenders that had come back clear in that limited criminal history. And so, not only does it have huge holes and gaps in data, when you see failure rates with a sex offender, it's a very serious, deficiency in that program. So the schools haven't used that system for a long time, and by state law are no longer allowed to use it for employment purposes. So, a core criminal package at a minimum should contain, these 4 items. This should be at the absolute base minimum. You're going to have a Social Security verification, which not only verifies identity, any other names they've been known by, where they've lived, address history. You're going to run it through a national criminal database, national sex offender, and then you're going to supplement that with a county criminal search. So you're going to look at, where have these folks lived at, and we're going to look and search at that local level. What we also add for all of our Indiana clients is a search called an Indiana Participating Court search, and with that we have integrated with about 2/3 of the county courts in Indiana. So we would run your names and alias names through that system at no additional package price, just to get that greater coverage, because we've got integrations with counties like Delaware, which Ball State, or Monroe, Indiana University. So it catches a lot of these college communities where your candidates may not live today, but they lived there for 4 years when they were going to college. And then we have other additional solutions like Bureau of Motor Vehicle Records, federal criminal searches, employment credit reports if you were hiring for, say, a CFO or a financial position. And then I mentioned e-reference check, or the automated reference checks, which quite honestly these days e-reference check would probably cost you about as much as a latte at Starbucks. So I mean, because of the technology, the cost of doing these deep competency-based reference checks, but allowing them to be automated is a lot less expensive than the traditional methods. So as we look at how do you document your due diligence, I think we're in a climate right now where it's never been more important for employers to make sure that they're partnering with a background screening firm that really understands everything that's going on in the world, because there's so many things that are happening, and if they're not keeping you abreast of all these changes and legal challenges and things that are going on, it just really puts the organization at a lot of risk. And so as we kind of lay the foundation for these 4 areas we want to look at, you've probably heard a lot about negligent hiring doctrine. And what that basically says is if you as an employer hired somebody that you knew or should have known was, a dangerous or unfit, and that you could foresee that somebody could be harmed, or they could, then you could be sued for negligent hiring. Well, I doubt any of you would hire somebody if you knew they were dangerous or unfit. So what really gets most employers in trouble is the should have known. And what this means is that something happens within your organization, maybe a lawsuit is filed, and through that disclosure process they realize A, you weren't doing background checks, or B, you were doing very limited or low quality background checks. then the argument might be made that had you been doing background screening correctly, then it would have revealed that this person had a history of, violence or, theft, and you wouldn't have hired them, and so thus you could have prevented this from happening. This was actually applied to a volunteer organization here in Indiana about a decade ago because they allowed a person to coach a Little League baseball team who was a convicted sex offender. They didn't do any background checks. He molested 2 kids on the baseball team, and so the lawsuit basically took this approach, and the courts agreed. They said, had you done a background check, it would have revealed he was a sex offender. You would not have allowed him to coach, and therefore these 2 kids would not have been harmed. So that's kind of what negligent hiring says. And then negligent retention deals more with your existing employees. And I would say, from the get-go that background screening should be approached as a long-term process. It's not a one-and-done pre-employment process, because we can run a background check today. You can bring them into your organization. They can go home tonight and commit a crime on the way home, commit domestic violence at home tonight, rob a bank, whatever. So it needs to be an ongoing process and to document your due diligence. And so as we look at that, it kind of segues us into these kind of 4 hot button areas that we're seeing in background screening today. Ban the box. If you've not heard of this, chances are you're going to hear about it. It is popping up all over the country. I think the first place that I saw this kind of show up, I think it was in Philadelphia about a year and a half ago. It has already popped up in Indianapolis. It is passed in Indianapolis on a more limited basis. I think it's only going to apply to government is where it looks like it's going right now. And so what Ban the Box says is this, is that you can no longer ask questions on an application concerning criminal history. So it would remove those questions about criminal convictions, pending cases, those kind of things. Anything related to criminal history would not be allowed on an application. And so, my argument is you're removing a valuable integrity tool for employers, because I know of our 2,600 clients that we work with, those that we work with, very closely, I know that they are all looking at the background screening report. They're comparing it against the application, and there are times when we might return a criminal case, say a conviction for public intoxication, which you say, hey, wouldn't have any bearing on our hiring decision. However, when I compare that against the application, what I find is they didn't disclose it. So now we got an integrity issue. So now from first contact or with our organization, they're already dishonest. So maybe I'm not going to hire them because of the dishonesty. So it would remove that opportunity, because you would no longer have that information on an application that you could compare against. The theory behind it is that ex-offenders are being disenfranchised, that their criminal history is preventing an opportunity to make it to the interview stage, and if we remove the criminal history information from the application, then it would allow them the opportunity to explain themselves at an interview. And so, the problem therein lies, how do you validate if what they're saying is actually the truth? I mean, just because they've explained it, how do you know whether or not that is true or not true? It doesn't prevent you from talking about the criminal history at the interview, and it doesn't prevent you from conducting criminal background checks. It just pushes that in the process further down the pike until you get to the interview stage. So it's one of those areas you really need to keep an eye on, because it's growing. I mean, it really is snowballing across the country, and as it does that, more and more communities are going to start moving in this direction. It started out as more of a municipality-driven issue, but now we've seen, I think, up to 7 or 8 states have got pending legislation that would enact it statewide. Haven't seen anything here in Indiana at the state level. It's all been at the local level, primarily in Marion County. The other big area, the second one, is the EEOC. And if you've been following this over the last 12 months, the EEOC passed their 2012-2016 strategic plan last April, and primarily the main target in this strategic plan is, background screening and the proliferation of background screening. And so they approved this 4-1, and the guidance was effective immediately. No public comment on this, but it became the game plan for the EEOC field offices. And so what it did is it replaced the 1987 EEOC policy statement regarding conviction records. And so, we're going to talk a minute here about zero tolerance policies, shouldn't have them, and really looking at, kind of your three-pronged approach to make sure that, these green factors is what they're called, to make sure that your policies are following these green factors, which say, you need to be looking at three things every time you're reviewing a criminal record. What's the nature of the crime, how long ago was it committed, and how would that, criminal record impact the position for which they've applied. And so, we need to really be filtering our information through a policy like that. It also replaced the 1990 policy guidance on consideration of arrest records. The lone dissenter, Commissioner Barker, said, utter lack of transparency. The public has been intentionally shut out of the process. It's going to place a huge burden on business owners. And that basically it's exceeded the authority for a regulatory commission. They're not a Congress and they're not the courts. And it's been a little bit in conflict with Congress because Congress really hasn't allocated any money for the implementation, though we've seen several cases over the last 12 months where the EEOC has gone after traditionally larger organizations that appear to not be following the strategic plan. So disparate impact is probably the term you would hear most often. So now the burden is on the employer to show, that your policy is job-related and consistent with your business necessity. And the EEOC is really interested in who's being denied based on these background checks and whether or not there's any disparate impact on any protected classes. So the case law, I mentioned the green case, that's the three-pronged approach we just talked about. The case EEOC doesn't necessarily say that there's any kind of time stipulation here, like you can't use a case that's older than 10 years or anything like that. In the SEPTA case, it was actually their policy was, no violence, and an applicant had a murder conviction from 40 years ago, and they didn't hire based on that, and the Third Circuit Court found in favor of the company. So, the key things to remember here is, one, that you're looking at these green factors: nature, gravity of the crime, time has passed, and what is the job they're seeking. And then, a couple other things that I think are real critical for organizations to do is, one, you need to consider, okay, if I've got a candidate for employment, they've got a criminal record, I've run it through the green, three factors of green, and I also know that, I work for, Hospital A, and they were recently employed at Hospital B, and that we, did our research in Hospital B. There have been no issues related to that criminal record at Hospital B, that I now need to consider that if they've been employed in a similar position and nothing has happened and that conviction was before, that I have to consider that as well. And then the other thing that I think would be critical for employers to do is that you need to allow the applicant or the employee to explain the circumstances of the conviction, which is going to happen on a pre-employment basis, or if you're using a background screening firm, because if you're going to deny them employment, you have to, allow them an opportunity to review any information that's going to be used against them. But just making sure that you give them that opportunity would just add a further layer of protection for your organization. So that's kind of what I just mentioned, looking at, recent employment. Arrest records, obviously you need to be very careful with those. As of Monday, you really shouldn't be seeing those in Indiana anymore because they will have been eliminated and not allowed to be viewed for any purposes, not just employment. I think the statute says any activity, which would mean volunteer organizations or, rental, lease properties, anything. So we've talked about those considerations. The third one we want to talk about is the Federal Fair Credit Reporting Act. This one generates a little bit of confusion because folks think, well, man, we're not doing any credit history. We're not looking at credit information, so why would I have to follow the Fair Credit Reporting Act? Well, it's probably one of the more poorly titled laws that exist, because even though it says fair credit, the law really should say Fair Consumer Reporting Act, because the FCRA, which is the Fair Credit Reporting Act, it dictates any type of background screening. You could just be running motor vehicles through a third party like Safe Hiring Solutions, or you could just be doing employment verifications or education verifications. But if you're outsourcing any of your background screening process to a third party for a fee, then the Fair Credit Reporting Act attaches. And what your requirements are looks like this. On every one of your candidates, you've got to issue a disclosure statement and receive authorization, either in writing or electronic. And those can be in one document. And so, if you're working with a background screening firm, you should have some kind of disclosure statement and authorization form. And then if you take adverse action, which is based in whole or part on a background screening report, based in whole would be, we do a background check and we find they were convicted of, child molesting, so we're not going to hire them. Based in part would look more like this. We do a background check, they got a public intox conviction, compare that to our application, they didn't disclose it, so we're not going to hire them based on the dishonesty. So it wasn't really the criminal record, but the dishonesty would only be known because of the background screening report, so it's based in part on the screening report. So if it's based any form whatsoever on the background screening report, then you have to follow a two-step process. The first step is you have to issue a pre-adverse action letter. You have to issue a copy of the report and a summary of the rights under the FCRA. So your candidate that you're going to deny has to receive these three things. The pre-adverse action letter should have toll-free number and contact information for the screening firm, because it should stipulate, if you want to know why you didn't get hired, then they need to call you. If they want to dispute information in the report, then they need to contact, Safe Hiring Solutions or the screening firm to dispute the information. So then basically you would wait 5 business days. If they don't dispute anything within those 5 business days, then you would issue the adverse action letter. So it requires that your denial of that employment position be a two-step process now, which provides information for a candidate to see what's going to be used against them. And it's really critical that you're doing this. As we look at a few lawsuits here, these recent lawsuits, you're going to see these companies, and several of these you'll recognize company names, they were sued not because of the criminal record itself and why they didn't hire them, but they were sued because they didn't follow these steps, or they didn't receive proper authorization, or they didn't follow the two-step adverse action process. And this one in front of us, Hunter versus First Transit. And First Transit actually is a company that does a lot of work in Indiana, and they just settled for almost $6 million because of not following these required steps of the FCRA. Domino's Pizza, $2.5 million. HireRight, which is actually a competitor and a screening firm, they were providing inaccurate information, which violates the Fair Credit Reporting Act. So they weren't verifying information. They had a $2.5 million settlement. Kmart settled a $3 million FACRA violation settlement. So these are just a few big, large examples of what the kind of legal climate looks like out there today for not following those specific required steps of the FCRA. One of the things we've done in our system is to make sure that we've made this process easy. So we've built in the pre-adverse and adverse action process. So as you run a background screening report, you run one on John Smith and you determine you're not going to hire John, there's a little button out to the next to John's name, and what you would simply do is click on that button. It would create the pre-adverse action letter, copy of the report, summary of their rights. All you have to do is print it and mail it, and then you would just come back, in 5 business days and open up John's report again and click on adverse action. It would create that letter for you as well. So we're constantly, striving to make sure we make these processes for compliance very easy. And I say that as we're going to have a huge, platform upgrade going into the fall when we release it. One of the things we're going to do is we've created a platform that makes it much easier to integrate with. So if you're using, your homegrown HRIS system or an ATS or Taleo or some of these, that everything could be controlled from in that one portal, and you wouldn't even have to log into our system, so that we could integrate within whatever human resource system you are currently using. The last big one here is social media background checks, and this is one that's been brewing for some time. Some of you may actually be doing some of this on a limited basis yourself, little Google searches or checking around on the internet. Up until recently, the FTC at the time, and now it's the Consumer Financial Protection Bureau, has taken over guidance on the Fair Credit Reporting Act. But up until they took over, this past January, the FTC had basically kind of been quiet on this issue, but they did make a ruling last year that gave some limited okay to using social media checks if a couple things were met. One, you were using a third party, somebody out of human resources who could filter the information, and two, that you would verify the information, which is really extremely difficult when you're looking at social media. So some of the things I would say is be really careful, because there can be some real legal implications like discrimination. Now all of a sudden, as you're doing social media checks, you're seeing a lot of protected information, marital status, age, race. There's lots of things that you're going to see that you wouldn't see on an application. Privacy. Yes, even the internet has a reasonable expectation of privacy, because Facebook, Instagram, a lot of these sites, social media sites, typically have some form of friending, which means I have to give you access. And there has been a couple lawsuits, multi-million-dollar lawsuits, where organizations had actually done social media checked and gained access to somebody's MySpace, which is not very popular anymore, or Facebook account, without their authorization. And so you still have some privacy issues. And then the big one for me is there's kind of an authenticity problem. How do you know it's your candidate? You're running a John Smith. We don't have a date of birth. We don't have a social security number, address. How do we know that's your John Smith's Facebook page? How do we know that it's their blog that you're reading or Instagram page? So authenticating information becomes very difficult. And not only that, the other real concern is, how do you verify the information? It's not like we go into a court of record like we do now in a criminal case. How do I verify a blog or a Facebook page? How do you know it's your candidate? Probably from a violent crime detective background, which I had, my biggest concern would be, some of the folks that are applying, if they're very sophisticated online and doing, predatory things online or things they're not supposed to do, they're not doing that under their real name. They're not doing that under their, the email address they've provided you. I mean, they're slick enough and smart enough that they're operating under assumed names online. And so, there's an assumption here that, just because somebody comes back clear in a social media check certainly doesn't mean they're clear. It just might mean they're smart enough they're not operating under, their name or email address that they typically use. So 21 states have restricted the use of social media checks. Congress has a bill pending, HR 537, that would make it illegal to ask for social networking and email passwords. So there's enough concern at the state level and even the federal level about these concerns that we're seeing legislation kind of pop up here. So we went through that kind of quick at about 35 or 40 minutes. So what I'm going to do is, I'm going to take a break here and open up the chat box and see if you have any questions. So hang with me for just a second. All right, not seeing any questions. Either I put everybody to sleep or maybe we answered most of them. I would be more than happy to if you want to shoot me an email, what I can do is email back the special pricing. And one of the things I would say, and I haven't even talked to Dean about this, is we're even adjusting the e-reference check pricing. And right now, as it's coming out, we're going to lower that pricing right now too for a short period of time. So I'm going to update the special pricing that you guys receive, and just email me, give me a call if you have any questions. Like I said, this information was recorded, so we'll have it up on the website probably within about 24 hours or so for any of your colleagues. Hope you have a great day. Thanks.